Hey, it's Bilal from Pacific Workers, and today we're going to talk about penalties and sanctions. That's right, we're going to talk about how to get the most money you can from the insurance company when they're screwing around and not doing their job. The first thing to know is generally there's a couple different ways to get penalties and sanctions. Probably the most common is either A, because your treatment isn't authorized on time, or B, your money isn't being paid on time. Usually that means either a temporary disability check is missing, a permanent disability check is missing, a reimbursement for out-of-pocket expenses is missing, generally one of those things. I'd say the most common is temporary disability. So generally you should know temporary disability is paid every 2 weeks as long as you have a work status saying that you're actually temporarily totally disabled or partially disabled and your employer cannot accommodate your work restrictions and you're within your statutory timeframes, etc. You should be receiving temporary disability benefits, which are calculated generally based on 2/3 of your average weekly wage leading up to your date of injury, or what your expected wage would be if you were to get raises and things like that going forward. Like I said, there's also treatment authorization issues, meaning that the insurance company generally has time limitations on when they can conduct what's called utilization review, which is their process to either deny or authorize treatment. Typically, it's 5 business days or no longer than 14 days if they have requested additional information when determining whether or not they want to authorize the care you're going to receive. Now, if your case is admitted, you have a valid doctor who's requested authorization for treatment, and the insurance company has passed its time for utilization review, you can either A, seek penalties and sanctions, or B, just seek the treatment itself. And normally what we'd have to do is go to the Work Comp Appeals Board, you file what's called a declaration of readiness to proceed, and you indicate there are issues including penalties and sanctions as well as treatment authorization. Now you have to be careful because you should be filing a petition with the Work Comp Appeals Board before doing that, of course, to signify that you intend to seek penalties and sanctions and also make it an issue for trial. And then you also want to pick the right type of hearing. Instead of what's called an expedited hearing, where you can only address the treatment issue, you want to request a mandatory settlement conference, which is a type of hearing where you can set a variety of issues, not just treatment issues. And the reason why you can't set a penalty and sanction issue for trial at an expedited hearing is because there are only certain types of issue the judge is empowered to hear at expedited hearings. The whole point behind an expedited hearing is that it's faster to get on calendar than it is another type of hearing, so that there's these immediate issues that need to be addressed quickly, namely treatment or payment of benefits and things like that. Penalties and sanctions are kind of it's an after the math issue that the judges aren't really concerned with insofar as them being a need of the injured worker right away. It's kind of like the cherry on top. And so ultimately, if you want to seek penalties and sanctions, you have to request the right type of hearing. Otherwise, you'll get to court and the judge will say, I'm sorry, we can't address that today. This issue will have to be deferred for another time. If you're doing this on your own, it can be complicated. You should probably have an attorney. But if you don't have an attorney, you can also check out some of the labor code yourself to figure it out. With respect to the expedited hearing issues, you can read those at Labor Code Section 5502, just for a reference point. And warning in advance, it's very difficult to read. I know legislative writing isn't fun to read, but it's there. And to this extent, you can make sense of it all. Good for you. I know a lot of lawyers still struggle with that. But you can check it out. It's there for you. You also want to check out Labor Code Sections 5814, which indicates that you have the right to seek penalties if there's an unreasonable delay in your treatment or benefits. And then you also want to check out, and it's probably the most common, Labor Code Section 5813. And this is a catch-all labor code section that really just generally states that if there's any bad faith or frivolous conduct on the part of a party, that the judge has the right to order penalties and sanctions. And this is just generally a catch-all tool that we often use as attorneys to hold the insurance accountable when they're playing around and they're not doing their job to get our clients the benefits and the treatment they need. Generally speaking, too, before you should always file for penalties and sanctions, you should try and engage in good faith, reasonable negotiations to try and resolve the issue before you actually reach out to the court. A lot of times the court will want to see that you've tried to do something on your own to rectify the issue before you've involved them. If the insurance company is 1 day late on payment of benefits and you haven't reached out to them, you haven't called them, you haven't tried to informally request penalties or try to resolve the issue on your own, and you simply just file for a court hearing, the court may get upset with you. So just know in advance, try and do what you can to work out the issues on the front end. If you can't do that, then you definitely want to get the court involved and you want to request penalties and sanctions. Now, generally speaking, the insurance company can't be just ordered to pay penalties and sanctions at a mandatory settlement conference. It has to be a triable issue. And so when you get to court, if you are there by yourself, or with an attorney. Generally, the parties will try and negotiate whatever the issue is before they close it out and set things for trial. And so the judge will want to know, hey, you guys are here, we're in court. Did you guys actually try and work this out on your own? Did the insurance company offer to resolve the penalties and sanctions, to the injured worker? Have you made a settlement demand to try and resolve the issue? Or the attorney, have you tried to resolve the issue? And assuming you can't reach an amicable resolution, then you would want to set the penalties and sanctions issue as well as whatever the underlying issue is for trial. Now, be aware, and it's a sneaky tactic, oftentimes what the insurance company will do is it will authorize the disputed treatment or pay the retroactive benefits that are due without necessarily addressing the penalties and sanctions issues. And they do this because they try and get to court and then argue, well, judge, the underlying issue is resolved. The only thing that's unresolved is the penalties and sanctions issue. And usually then, to some extent, the court likes to prioritize what matters it sets for trial. And I've had judges before decide, because the underlying issue is resolved, that they're not going to hear the penalties and sanctions issues by itself, and they'll ultimately defer that to the end of the case. And that's not great to hear. Basically, you're kind of kicking things down. You're kicking the can down the road a little bit, and you're going to say, hey, look, it's not really that important. The treatment issue is resolved. The benefits are being paid. Whatever it is done. So we don't want to take our time with this trial on this other smaller matter because it's just not that important, quite frankly. And I get it. The judges are extremely busy and they have really pressing calendars. They've got a lot of important stuff going on. There's some people that are catastrophically injured that aren't getting the treatment or benefits they need, and the judges view that as more important than addressing, a smaller penalty for a late payment on mileage reimbursement or something like that. So I understand, but just know from the court's perspective, they're trying to prioritize things. Now, what happens when things are kicked down the can, when penalties and sanctions are deferred? Ultimately, those become an issue for the end of the case. And typically what the insurance company likes to do is resolve all those things all at once. So they'll say, hey, you know what, you had a penalty petition for this treatment, for these benefits pending throughout the case. We'd like to wrap that up into what's called a compromise and release settlement, where they just pay you to go away for everything. And they do that because the insurance adjusters don't want to mark on their record. Ultimately, if an insurance adjuster is forced either by order or other terms pay out a penalty or sanctions, it's kind of like a black mark on their record, right? Where they say, hey, you haven't done your job. This is flagged as, you being a bad adjuster. And so they like to avoid that at all costs. In addition, if a judge orders a penalty, then the insurance company can actually be audited. So they like to avoid penalties and sanctions as much as possible, which means that sometimes they like to bury it in things. Whether this is right or wrong, as long as you're getting your money's worth, it makes sense. And usually when we're negotiating a settlement, we'll often ask for more money on top of what we think the value of the case is, because we want to make sure that you are getting the compensation you deserve. Whether or not it's actually described as a penalty in the settlement is sometimes a moral question, and oftentimes we try to negotiate with the insurance adjusters to ensure that it's at least accounted for outside of the value. And if they want to call it whatever they want to call it, that's okay with us. And you'll see that sometimes that becomes a sticking point because they really don't want it written in specifically as a penalty payment, even though you're getting your money's worth. That being said, we also want to be careful that they're not just kind of brushing it under the rug, and they're actually giving you more than what your case is worth to make sure it's accounted for separately. But generally you'll see, hey, the settlement's worth $40,000. We think there's $5,000 in penalties and sanctions that we want, so we'll ask for $45,000. Whether they give us that extra $5,000 in the form of penalties separate and apart. Again, as long as you're getting your money's worth, we typically think that that's a reasonable and amicable resolution to those issues. So if you are seeking penalties and sanctions, just know there's a multitude of ways to do it. There's a lot of labor code sections that address these issues. There's very specific court procedures. You can get penalties and sanctions, and there's a lot of cases in where it's completely warranted, and we often do seek those things. But it is a process. It is complicated, and you want to make sure you're doing it right. So if you're comfortable negotiating the process on your own, please do. If you need help, reach out to us.